Can you modify final orders for legal decision making or parenting time in Arizona? The answer is yes, and in this video I'll explain how. First of all, my name is Robert Larson. I'm an attorney and the owner of the Larson Law Office in Mesa, Arizona, and this is an issue that frequently comes up in family court. So when you get to the end of a divorce case or a custody case, you're going to end up with final orders for legal decision making and parenting time. And I explained these a little bit more in detail in a different video, and I'll try to link that below. But basically, legal decision making is the right to make decisions for your kids, and parenting time is the schedule when you're going to have your kids with you. So when you get to the end of the case, you get final orders, but that doesn't necessarily mean they are permanent orders. It's a little bit tricky, but basically final orders just means your case is over, but you can reopen it and possibly modify those orders in the future as long as you have three things. One, enough time. Two, a change of circumstances. And three, the best interest of the children. So let's take those one at a time. The standard rule is that you have to wait at least a year before you can go back to court and ask for modification. And the reason for that is they don't want people just constantly going back to court just because they don't have court orders that they don't like. If they didn't have this rule in place, it's possible that someone could get to the end of a trial and have a judge issue rulings that someone doesn't like, and they could go right downstairs and file for another modification the same day or the day after, and it would just be a never-ending series of litigation. And some people find ways to do that anyway, but they try to avoid that. So the general rule is that you have to wait at least a year before you can ask the court for modification. And there are a couple of exceptions. One exception is if it's been 6 months and you're not really following the parenting schedule, you can ask to modify the parenting time schedule under those circumstances after 6 months. The other exception is anytime there's an emergency, you can go to court and ask the court for an emergency order. It's not easy to get, but there's no time requirement when it comes to an emergency situation where your kid's safety is at risk. So that's the first thing, is time. The second thing is a change of circumstances. They're not going to modify your court orders just because time has gone by. If nothing has changed, if basically everything is still the same as it was when the current court orders were put in place, the court looks at it like there's no reason to change anything. So why would they modify your court orders if everything is still the same? Now, the change in circumstances doesn't have to be a lot. The law says it has to be a material change of circumstances, but a lot of things can qualify as a material change of circumstance. It could be that one parent has moved closer or farther away. It could be that one parent, maybe in the court orders, were told to do some things like take some classes, do some drug or alcohol rehabilitation, or various other things that needed to be done, and maybe they've completed those things. Or it could be that the relationship between the children and one parent has gotten better or gotten worse, or someone's work schedule has changed. There's a lot of things that could be a material change. I don't want to try to list everything because it would just be impossible. So it doesn't take a lot to be considered a material change of circumstances. So if you have those first two things, the time and the change, then you can at least get to a trial. If you don't have those first two things, the judge could deny your request and dismiss your petition for modification without even giving you a trial. So if you get past those first two steps, then you get to the third, which is you go in front of a judge and you have a trial, and then the judge has to decide what's in the best interest of the children. So just because you have the time and the change of circumstances doesn't automatically mean the judge is going to modify your court orders. The judge still has to listen to your evidence and testimony, and based on the total circumstances, decide what's best for the children. And so if you have all three of those things, enough time, a material change of circumstances, and it's in the best interest of the children, according to the judge, to modify your court orders, then the court will modify those orders and you'll have new final orders, and start the process again, where if someone wants to modify it in the future, they would again have to wait another year and have another change, and so on. So that's how it works in Arizona. We do a lot of modification cases. In most types of law, once you get final orders, that's it. And even in family law, when it comes to divorces, for example, when it comes to like property division and things like that, those orders are not modifiable. But parenting time and legal decision making are a little bit unique because the law recognizes that kids need what's in their best interest, not only when you go to court the first time, but throughout their entire juvenile lives. And so the court needs to have that ongoing jurisdiction to be able to modify things as necessary. So there's also an opportunity to modify child supports or spousal maintenance, those have different rules, and that'll have to be a different video for another day. But if you ever have any questions about modifying your legal decision making or parenting time, feel free to contact us. We'll be happy to help.